Is wholesaling real estate legal in Texas? Do you need a real estate license to wholesale in Texas? And why are so many people online suddenly saying that wholesaling has been banned or made illegal? If you've searched any of those questions, you're not alone, and chances are you're more confused now than when you started. There are a lot of videos being made right now about wholesaling in Texas, but most of them aren't actually about wholesaling. They're about marketing laws, they're about cold calling, and they're about text message regulations. And those topics are being presented as if they determine whether wholesaling itself is legal, which simply isn't true. So let me say this clearly right up front. Wholesaling real estate is legal in Texas when it's done correctly. And the key word there is correctly. I'm going to walk you through the actual Texas laws that apply to wholesaling, the specific statutes that you need to understand, and the Texas Real Estate Commission's position on wholesaling, and the new disclosure requirements that went into effect, and how to wholesale real estate in Texas without relying on cold calling or text messaging at all. This is going to be a law-based explanation, not a hype video. If you don't know me, I'm Ryan Zomarodi. I'm a full-time real estate investor, and over the years, I've done deals across more than a dozen states and built a multi-million-dollar real estate portfolio that generates consistent passive income. I'm also the co-founder of Real Estate Skills, where we help investors nationwide wholesale real estate, flip houses, and invest legally and sustainably. For this video, I didn't rely on internet templates or secondhand interpretations. I consulted directly with a Texas real estate attorney, reviewed Texas statutes, studied guidance from the Texas Real Estate Commission, and analyzed data from the Texas Real Estate Research Center. I've also personally reviewed the wholesaling laws in every single state and published in-depth state-by-state wholesaling legal guides, updated meticulously, which you can find on the Real Estate Sales blog. Everything you're going to hear in this video is grounded in real law, not YouTube influencer opinion. And because I want this to be as practical as it is educational, I also want you to know this. I personally paid over $1,700 out of pocket to have a Texas real estate attorney draft Texas-specific wholesaling contracts for me and my wholesaling business. That includes a Texas assignment contract, a disclosure form for the seller, and a disclosure form for the end buyer, as well as a Texas purchase agreement suitable for wholesaling, all in compliance with the laws I'll be covering later. And I'm giving away those documents for free as a resource for this video. You'll see the download links below, or you can go directly to realestateskills.com/Texas to get your free copy. This isn't a gimmick. It's the same paperwork that we used to do deals legally in Texas. Now, here's the most important thing I want you to understand before we go any further. Wholesaling is a contract strategy, not a marketing strategy. And most of the confusion around wholesaling in Texas comes from people mixing those two things together. Texas law regulates conduct, it regulates disclosure, and it regulates brokerage activity. It does not ban the act of assigning a contract. So in this video, we're going to separate fact from fiction, law from noise, and clarity from fear. To do that properly, we need to start with the basics. So in the next section, I'm going to answer a foundational question that surprisingly few videos ever get right. What is wholesale real estate, legally speaking? Let's start there. And this matters because if you misunderstand what wholesaling actually is, everything else about the law will sound confusing or even contradictory. At its core, wholesale real estate, also called real estate wholesaling, is a contract-based strategy. It's not a marketing strategy, it's not a brokerage service, and it's not listing or selling a property on behalf of someone else. Wholesale real estate is when you enter into a purchase agreement as a buyer. You obtain equitable interest in that contract, and then you sell or assign your contractual rights to another buyer before closing for a fee. That's it. You are not selling the house. You are selling your position in a legally binding contract. This distinction matters a lot because under Texas law, real estate and contracts are treated very differently. Selling real estate can trigger licensing requirements. Selling your own contractual interest does not. That difference is the legal foundation of wholesaling. Let's talk briefly about equitable interest because this term comes up often and sounds way more complicated than it actually is. When you sign a purchase agreement, you don't own the property yet, but you do own rights under that contract. Those rights include the right to close on the property, the right to enforce the contract, and the right to assign the contract, unless assignment is specifically prohibited in that contract. That bundle of contractual rights is called equitable interest. Under Texas law, equitable interest is a transferable contractual property right, not legal title. And Texas law allows contractual property rights to be assigned unless the contract states otherwise. That's why wholesaling works legally in Texas. You're not selling the property, you're assigning your contractual interest. This is actually where a lot of people get tripped up. Wholesalers are not acting as middlemen. They're not connecting buyers and sellers for a fee, and they're not representing the seller. They are acting as principals, buyers who might later decide to sell their contractual position. That difference is not semantic, it's legally defined. So let me be very clear about what wholesaling real estate is not. Wholesaling is not texting homeowners hoping for a response, listing a property for sale, marketing a property that you don't own, representing a seller, or negotiating on someone else's behalf for compensation. Those activities fall under brokerage law. Wholesaling does not, when done correctly. This is why when people ask questions like, what is wholesale real estate? Is wholesaling real estate legal? Or do you need a license to wholesale real estate in Texas? The answer always starts with how the transaction is structured, not how leads are generated. Once you understand that wholesaling is fundamentally about contract law, assignment rights, and equitable interest, the Texas laws we're about to cover start to make a lot more sense. Because wholesale real estate is, at its core, a contract strategy, not brokerage and not marketing. And Texas law doesn't regulate strategies. It regulates contracts, disclosure, and conduct. So now that we've clearly defined what wholesale real estate actually is, we can answer the next and most important question. Is wholesale real estate legal in Texas? To understand why wholesaling real estate is legal in Texas, we have to start with Texas contract law. Because wholesaling does not exist because of marketing tactics, creative strategies, or investor culture. It exists because Texas law allows contracts to be assigned. In Texas, a real estate purchase agreement is a legally binding contract. When you sign that contract as a buyer, you obtain rights under the contract. Those rights are contractual property rights, not legal title to the real estate itself. And under Texas law, contractual property rights may be assigned unless the contract specifically prohibits it. That single principle is the legal backbone of wholesaling. Now, remember this is very important to understand. In Texas, contracts are assignable by default. That means assignment is allowed unless the contract says otherwise. Texas law does not require special permission from the seller or a separate statute authorizing assignment or a real estate license just to assign a contract. Assignment is part of basic contract law. Remember that. Wholesaling real estate is simply the act of assigning a purchase contract to another buyer before closing. Nothing more. When wholesalers assign a contract, they are not selling real estate. They are selling their contractual position. That distinction matters legally, and Texas law recognizes it. This is where a lot of misinformation starts online. You'll hear things like assignment contracts are illegal, or Texas doesn't allow assigning contracts anymore, or you can't assign contracts without a license. None of those statements are accurate. Texas has never prohibited assignment of real estate contracts. Instead, Texas regulates how contracts are structured, how parties disclose their interests, and how people behave in transactions. Assignment of contract itself has always been lawful. Remember, when you enter into a purchase agreement, you acquire equitable interest. Equitable interest gives you the right to close on the property, the right to enforce the contract, and the right to assign the contract unless restricted. That equitable interest is what wholesalers sell, not the property itself. This is also why assignment does not automatically create a licensing issue. When you assign a contract, you are acting as a principal. You are selling something that you own, your contract rights. You are not acting on behalf of the seller, representing your cash buyer, or negotiating for another party for a fee. Those activities fall under brokerage law. Assignment of contract does not. Now, just because assignment is legal does not mean Texas leaves it unregulated. Texas law cares deeply about transparency. That's why the state added specific disclosure requirements related to the assignment of equitable interest. And that's exactly what we're going to cover next. Because while Texas allows assignment, it requires that certain facts be disclosed clearly and properly before the assignment of contract occurs. So now that you understand why assignment of contracts are legal under Texas contract law, the next question becomes, what does Texas require wholesalers to disclose? And when do those disclosures have to be provided? That brings us to one of the most important concepts that you need to understand, and that's Texas Property Code Section 50205, Equitable Interest Disclosure. Texas Property Code Section 50205 is the law that directly addresses the assignment of equitable interest in real estate transactions. And this is where I want you to pay very close attention, because this law is often misunderstood, misquoted, or used incorrectly to scare people into thinking wholesaling was banned. It wasn't. Instead, it does require one very specific thing. It requires disclosure when a buyer assigns their equitable interest in a purchase contract. That's it. The existence of this law actually confirms something very important. Texas acknowledges that assignments of contract and wholesaling exists. If Texas wanted to ban wholesaling, this law would not exist at all. To dive even deeper, let's actually read the legal code together. And don't worry, I'll translate this into plain English right after. Section 50205, Equitable Interest Disclosure. Before entering into a contract to sell an option or assign an interest in a contract to purchase real property, a person must disclose in writing to 1. Any potential buyer that the person is selling only an option or assigning an interest in a contract, and that the person does not have legal title to the real property. And number 2, the owner of the real property that the person intends to sell an option or assign an interest in a contract. Okay, let's break that down. Under this law, which went into effect September 1st, 2024, when you assign your interest in a purchase contract, you must disclose that you are selling or assigning an equitable interest, not the property, and that you do not yet own the property. And you also have to disclose that you're transferring contractual rights to another buyer. And that disclosure must be delivered to 2 parties, the first of which is the seller or the property owner that you're working with. The second party is the end buyer, also called the assignee. So, when must the disclosure be provided? This is one of the most important points in this entire video because I know that most people get this wrong. Based on my direct consultation with a Texas real estate attorney, here's what you need to understand. These disclosures do not have to be provided at the time that the purchase contract is signed. Let me repeat that because this is critical. The law does not require disclosures at contract formation or at the time the offer is accepted. What the law requires is that the disclosures be provided before the assignment of contract occurs. In other words, these disclosures are required to be sent to all parties before you assign the purchase contract to your end buyer. That distinction matters. Now, you might be wondering, does the seller have to sign the disclosure? No. And this is another area where people get confused. Under Texas Property Code Section 50205, the seller does not need to sign the disclosure. The disclosure simply needs to be delivered to the seller. The purpose of the disclosure is transparency, not approval. It's not asking for permission to assign, it's simply disclosing the nature of the buyer's interest. So why does this law even exist? I think this law exists for one reason: to make sure that everyone involved in the transaction understands who owns what and what is actually being transferred. It protects sellers from confusion, end buyers from misunderstanding, and wholesalers from accusations of misrepresentation. When used correctly, this law actually reduces legal risk. It doesn't create it. And the best practice, which is what we teach, is to use 2 separate disclosure forms. One disclosure delivered to the seller and one disclosure delivered to the end buyer. Both disclosures should clearly state that the wholesaler holds equitable interest, that the wholesaler is assigning contractual rights, and that the wholesaler does not yet own the property. This is exactly how the law is intended to function. This is also why we had a Texas real estate attorney draft Texas-specific disclosure forms for us. They are designed specifically to comply with Texas Property Code Section 50205. I paid over $1,700 to have these documents drafted, and I'm giving them to you for free as part of the downloadable resource below this video. If you haven't already, click the link below this video to get your free copy, or just go to realestateskills.com/Texas. Now that you understand why assignment is legal under Texas contract law and what Texas requires wholesalers to disclose, the next question becomes, do you need a real estate license to wholesale in Texas? And to answer that correctly, we need to look at Texas licensing law, specifically the statute that defines what a broker actually is. The law that governs real estate licensing in Texas is found in the Texas Occupations Code, Chapter 1101. And the specific section that matters most for wholesalers is Section 1101.002. This section defines what activities legally require a real estate license. So instead of guessing, let's go straight to the source. Under Texas Occupations Code Section 1101.002, a person must be licensed as a real estate broker if they're acting for another and for compensation to do things like sell real estate, lease real estate, negotiate a transaction, or represent a buyer or a seller. The key phrase here is for another person. This language matters. When wholesalers operate correctly, they are not acting for another person. They are acting for themselves. They enter into a purchase contract as a buyer. They acquire equitable interest, and then they sell or assign their own contractual rights. They are principals, not agents. That distinction is what keeps wholesaling outside of licensing requirements. Licensing issues arise not because of assignments of contract, but because of behavior. A wholesaler starts to cross into licensing territory when they market a property they don't own, represent a seller, negotiate on behalf of someone else, or present themselves as a middleman instead of a buyer. Those actions can trigger licensing requirements. Assignment of contract alone does not. This is why how you describe what you're doing is so important. You are not finding buyers for sellers, selling houses that you don't own, or even acting as an intermediary. You are signing a contract that you own. That framing isn't just semantics, it's legal positioning. Proper disclosure reinforces this distinction. By clearly disclosing that you are a buyer, you hold equitable interest, and you are assigning contractual rights, you further establish that you are acting as a principal, not a broker. This is why disclosure and licensing law work together. Assignments don't mean brokerage. You might hear people say if you assign contracts, you need a license. That statement is false. And if that were true, assignment would be illegal statewide, and it isn't. Texas law does not prohibit principals from selling their own contractual interests. So let's answer the question clearly and directly. Do you need a real estate license to wholesale real estate in Texas? No. As long as you're acting as a principal, selling your own contractual interests, and complying with disclosure and conduct requirements. Licensing is triggered by representation, not assignments of contract. Now, Texas law is one thing, but many people also want to know how regulators view wholesaling in practice. So next, we're going to talk about the Texas Real Estate Commission, also known as TREC, and how they define wholesaling and what that tells us about how Texas actually views this strategy. The Texas Real Estate Commission, widely known as TREC, is the state agency responsible for regulating real estate licensing and enforcement in Texas. So when people ask, what does Texas really think about wholesaling? TREC's position matters. And here's the key point I want you to understand right away. TREC does not say that wholesaling is illegal. In fact, TREC explicitly acknowledges that wholesaling exists, and they've gone so far as to study how it's actually being practiced all across the state. One of the most important and least discussed pieces of evidence on this topic comes directly from TREC itself. TREC didn't just casually mention wholesaling. They conducted a formal survey of more than 4,500 real estate industry professionals all across Texas to better understand how wholesaling is being used in real-world transactions. That alone tells us something important. Regulators don't just survey thousands of professionals about something they consider illegal. Following that survey, TREC published guidance explaining how wholesaling fits into Texas real estate law, and they define wholesaling very clearly. According to TREC's definition, wholesaling is a model where a person enters into a contract to buy real estate and then sells their contractual interest in the property to a third party prior to closing. That definition matters. TREC explicitly acknowledges assignment-based wholesaling as a known and recognized practice in Texas. Now, here's the most important part, and I want you to listen very carefully to this. TREC states, word for word, that individuals engaged in wholesaling are not required to hold a real estate license as long as they disclose their interest to potential buyers and do not otherwise engage in real estate brokerage activity. That single sentence clears up an enormous amount of confusion. But let's break that down in plain English. According to the Texas Real Estate Commission, wholesalers do not need a real estate license as long as they disclose their interest and they do not engage in brokerage activity. That aligns perfectly with everything we've already covered: Texas contract law, Texas disclosure requirements, and Texas licensing statutes. This is not a loophole. This is how the system is designed to function. This is also why it's misleading when people claim that TREC is cracking down on wholesaling. TREC is not cracking down on wholesaling. What TREC enforces is honest disclosure, proper representation, and licensing laws when brokerage activity is involved. In other words, TREC regulates behavior, not strategy. This mirrors exactly what Texas law does. So why does this all matter? The fact that TREC surveyed over 4,500 industry professionals, published guidance defining wholesaling, and clearly stated when a license is not required tells us something very important. Wholesaling is not operating in the shadows. It is a known, regulated, and clearly defined practice under Texas law when done correctly. Now that we've covered Texas contract law, disclosure requirements, licensing law, and TREC's official position, the next piece of the puzzle is the paperwork itself. Specifically, we need to talk about Texas wholesale real estate contracts because this is where wholesaling is either done correctly or dangerously wrong. When people run into legal trouble with wholesaling in Texas, it's almost never because wholesaling itself is illegal. It's because the contracts were wrong, incomplete, or misunderstood. So in this next section, I want to walk you through the 3 core documents that make up a compliant wholesale transaction in Texas. Let's start with the purchase agreement. In Texas, the most commonly used residential purchase agreement is called the 1 to 4 family residential contract, which is endorsed by the Texas Real Estate Commission. This is the exact same contract used by licensed real estate agents across the state of Texas. And here's an important fact that many people don't realize. The TREC purchase contract is assignable by default. That means unless assignment is specifically restricted in the contract, the buyer has the right to assign their interest. There is nothing in the standard TREC contract that automatically prohibits assignment. This is critical for wholesalers to understand. Using a TREC contract does not make wholesaling illegal. Using a TREC contract does not require you to be licensed. The risk is not the form itself. The risk comes from how you represent yourself, what you disclose, and how the assignment is handled. And of course, you can always use other purchase agreement to put wholesale deals under contract in Texas. Now let's move on to the assignment contract, which is the next document to conduct a compliant wholesale transaction. This is the agreement that transfers your equitable interest in the purchase contract to the end buyer. This contract typically spells out the assignment fee, the rights being transferred, the obligations of the assignee, and any other conditions related to closing. TREC does not provide a standardized assignment contract. That's why using a Texas-specific attorney-drafted assignment agreement is so important. Generic templates, out-of-state forms, or handwritten addenda often miss critical Texas-specific language. Remember, the assignment contract does not sell the property. It monetizes your contractual position. That distinction should be crystal clear in the paperwork. Now let's talk about disclosure requirements as required by law. This is the third piece and one of the most important, right? We're talking about disclosures. As we already covered in detail, Section 5 Texas Property Code 50205 requires disclosure when equitable interest is assigned. The best practice and what we teach is to use two separate disclosure forms, one disclosure delivered to the seller and one disclosure delivered to the end buyer or the assignee. Both disclosures clearly state that you are a buyer under contract, that you hold equitable interest, that you do not yet own the property, and that you are assigning contractual rights. This removes ambiguity and protects all parties involved. And you'll be in great shape when you're using the disclosure forms that my real estate attorney prepared to be in compliance with these Texas wholesaling laws. Now, just to reinforce what we covered earlier, these disclosures do not need to be provided at the time the purchase agreement is signed, but they must be delivered before the assignment of contract is performed and the transaction closes. The seller does not need to sign the wholesale disclosure for it to comply with the law. Disclosure is about transparency, not permission. So how do all these documents come together? When done correctly, a Texas wholesale transaction flows like this. First, you enter into a purchase agreement as the buyer. Then you obtain equitable interest. After that, you disclose your interest as required by law. Then you execute an assignment agreement with the end buyer. Finally, the end buyer closes on the property and you get paid. Each document in the wholesale transaction has a clear role. Each document also reinforces your position as a principal, not a broker. And this is exactly why we had a Texas real estate attorney draft all of these documents specifically for us. I paid over $1,700 to have a Texas purchase agreement, a Texas assignment contract, a seller disclosure for the assignment of contract, and the buyer disclosure for the assignment of contract, all drafted to work together and comply with the Texas wholesaling laws. And you can download all of them for free using the link below this video. Or just go to realestateskills.com/Texas to get your free copy right now. Now that you understand the contracts and paperwork required to wholesale legally in Texas, the next question becomes, why are so many people online claiming that wholesaling has been banned or made illegal? To answer that, we need to separate wholesaling law from marketing law because they are not the same thing. One of the most important and most misunderstood concepts in Texas wholesaling is the difference between marketing a contract and marketing a property. This distinction is at the center of most enforcement actions, licensing issues, and fear-based YouTube videos. So let's break it down clearly. When you wholesale real estate correctly, you are marketing a contract, not a property. Marketing a contract means you are offering to sell or assign your contractual rights under a purchase agreement. You are saying, in effect, I am the buyer under contract and I am selling my position in that contract. This is fundamentally different from selling real estate. Marketing a property means you are offering the real estate itself for sale. That activity typically involves advertising the property, describing it as if you own it, negotiating on behalf of the seller, or presenting yourself as a middleman. Those actions can trigger brokerage laws and licensing requirements. And this is where people get into trouble. Texas law and guidance from TREC focus heavily on how a deal is represented to the public. If a wholesaler markets a property they do not own, fails to disclose their role as a buyer, or implies they are representing the seller, they may be viewed as engaging in unlicensed brokerage activity. But when a wholesaler clearly markets their contractual interest with proper disclosures, that risk is dramatically reduced. Here's a simple way to think about this. If you say, I have a house for sale, you're marketing a property. If you say, I'm under contract to purchase a property and I'm assigning my contractual interest, you're now marketing a contract. Those two statements are treated very differently under Texas law. In fact, it's the same in a lot of other states. Many other videos online collapse these two ideas into one. They treat any form of wholesaling marketing as if it's automatically marketing property. That's incorrect. The law does not prohibit marketing contracts. It regulates how property is marketed and who is allowed to market it. This is also why disclosure is so important. By clearly disclosing that you are a buyer, you hold equitable interest, and you are signing a contract, you make it clear that you are not acting as a broker. Disclosure protects you because it clarifies your role. Once you understand the difference between marketing a contract and marketing a property, a lot of fear-based content online suddenly falls apart. Because many of the laws people cite have nothing to do with wholesaling itself. They deal with how people market, not whether wholesaling is legal. And that brings us to the next section. Now that we've clearly separated marketing a contract from marketing a property, the next logical step is to talk about the laws that are being misapplied in so many online discussions. Specifically, we need to talk about Texas marketing and solicitation laws, including recent changes like SB 140 and why they are often incorrectly used to claim that wholesaling is illegal. Most of the videos claiming that wholesaling is illegal or banned in Texas are not actually talking about wholesaling laws at all. They're talking about marketing law, and that distinction is critical. Texas, like many states, has laws that regulate how businesses are allowed to market and solicit consumers. These laws focus on things like cold calling, text message marketing, automated dialing, and unsolicited outreach. Their purpose is simple: consumer protection. They are designed to regulate marketing behavior, not real estate strategies. And this is where the confusion starts, because none of these marketing laws determine whether wholesaling itself is legal. They don't regulate contract law, assignment of equitable interest, purchase agreements, or the legality of wholesaling as a strategy. Yet many online videos take these marketing regulations and incorrectly apply them to wholesaling. Here's what's really happening. Many traditional wholesaling models that others teach rely heavily on cold calling sellers who just don't really want to hear from you, and sending unsolicited text messages, which is a legal gray area now in Texas, as well as large outbound marketing campaigns, which take a lot of time but really don't always work. When marketing laws become more restrictive, those tactics become riskier. So what you're often seeing online is marketers reacting to marketing regulation, not the law changing wholesaling itself. This is the core misrepresentation. Marketing laws regulate how you find deals. Wholesaling laws regulate how contracts are structured and assigned. Those are two completely different legal questions, and confusing them creates fear when none actually exists. Let me say this very clearly. If Texas changed marketing laws tomorrow, wholesaling would still exist, because wholesaling does not depend on cold calling. It does not depend on texting, and it does not depend on outbound marketing loopholes. Wholesaling exists because Texas contract law allows assignment and Texas law requires disclosure, not because of how leads are generated. This is why you have to be very careful about who you listen to on this topic. When someone says wholesaling is illegal now, what they often mean is my marketing strategy is now under pressure. It's totally not the same thing. So the real takeaway here is that wholesaling does not rise or fall based on marketing tactics. It stands on contract law, assignment rights, and disclosure requirements. Marketing is optional. Compliance is not. And that brings us to a very important question. If marketing laws are what's really driving fear and confusion online, then is there a way to wholesale real estate in Texas without relying on cold calling, texting, or aggressive outbound marketing at all? Well, the good news is there is. And that's exactly what we'll be covering next when I explain why MLS-based wholesaling is the safest and most compliant model in Texas. One of the biggest misconceptions about wholesaling is that it requires aggressive marketing, cold calls, text blasts, and mass outreach. In reality, it doesn't. That's simply how many people were taught to do it. Building lists, skip tracing, driving for dollars, PPC, direct mail, bandit signs. I'm sure you've heard it all. The reality is this. Wholesaling does not depend on marketing tactics. It depends on building relationships, submitting offers, and deal structure. And that's exactly why MLS-based wholesaling works so well in Texas. Wholesaling MLS properties is exactly what it sounds like. Instead of sourcing deals through off-market advertising, you work with properties listed directly on the MLS, which stands for the Multiple Listings Service. This is the largest database of properties for sale in any given market. We submit offers through licensed real estate agents. We also use standard Texas purchase contracts and assign contracts in full compliance with Texas law. There's no cold calling, there's no text marketing, and there's no aggressive or unsolicited consumer outreach. From a legal standpoint, this is huge because when you use the MLS as your wholesaling engine, the properties are already publicly listed. The sellers are already motivated to sell. You spend zero time or money on risky direct-to-seller marketing. The transaction already follows a standardized process, and the paperwork is already familiar to regulators and brokers. You are operating inside the most institutional and regulated framework in residential real estate. That dramatically reduces legal risk. Remember what we covered earlier. Marketing laws regulate cold calls, text messages, or unsolicited outreach. MLS wholesaling doesn't rely on any of that. You are strategically making quality offers on properties that are already listed to sell, as well as building relationships with real estate agents who will bring you deals on a silver platter. So those marketing regulations, like the ones you've heard about in SB 140, simply don't apply and are actually irrelevant to how we run our wholesaling business. This is the above-board professional approach to wholesaling in Texas. So why is that? Texas law focuses on contract formation, disclosure requirements, as well as licensing and representation. MLS-based wholesaling fits cleanly into that framework. You are acting as a principal buyer, using assignable contracts, and making required disclosures, as well as not representing any other parties. This is exactly how Texas law expects principals to operate. This is also why wholesaling from the MLS is such a solid strategy for beginners. It removes marketing compliance risk. It eliminates gray areas around solicitation. It uses familiar and standardized contracts, and it creates a clear paper trail. You're not trying to reinvent the wheel. You're not trying to become an expert marketer. You're operating inside an existing, well-understood system. If you're worried about getting penalized for text message marketing to the wrong sellers, which has a $5,000 fine per occurrence, then you should definitely look at using the MLS offer system for your real estate acquisitions. This is exactly why for the past 8 years at Real Estate Skills, we have always taught an MLS-first wholesaling approach. Not because it's trendy, but because it's legally clean, it's scalable, it's sustainable, and it's evergreen. I mean, the MLS is not going away, and it's been consistently the best source of new leads for our real estate businesses. And it's aligned with how Texas real estate actually works. It's designed to survive regulatory changes, not panic because of them. Our flagship MLS offer system is a proven framework that allows anyone, anywhere to wholesale real estate directly from the MLS consistently and efficiently without spending a dollar on marketing. And this is also why the Texas contracts and disclosures we're giving you for free are designed to work seamlessly with MLS-based wholesaling. They were drafted by a Texas real estate attorney to support standard purchase agreements, proper assignment of contract, and compliant disclosures to both sellers and cash buyers. And you can download them for free using the link below this video. Or just go to realestateskills.com/Texas to download your free copy of these attorney-approved contracts. Now, before we move on, I want to quickly address something that I hear people asking all the time. What are the best cities to wholesale real estate in Texas? Instead of guessing or relying on anecdotes, we can look directly at the Texas Real Estate Commission data to see where wholesaling activity is actually happening. According to TREC, the top metropolitan areas in Texas where wholesaling transactions have occurred include the Dallas-Fort Worth-Arlington metro area. This is a metro of over 7 million people, anchored by finance, logistics, and corporate headquarters, with constant deal flow and deep buyer demand. Then there's the greater Houston area, one of the most diverse economies in the country, led by energy, healthcare, and shipping, creating consistent transaction volume across multiple submarkets. Then there's the San Antonio, New Braunfels area. This is a rapidly expanding metro supported by military installations, healthcare systems, and population growth, often viewed as one of the more accessible Texas markets for new wholesalers. Following San Antonio is Austin, fueled by technology, startups, and high-paying jobs with strong appreciation and active investor demand despite tighter margins. Finally, there's the Dallas-Plano-Irving area, which is a dense corporate and employment corridor within northern Texas, known for stable demand, strong rents, and consistent buyer activity. Here's the simple takeaway. You can wholesale real estate in any market. But when you focus on markets where more transactions are happening, more investors are active, and more deals are closing, wholesaling just becomes a lot easier. These major metro areas in particular see higher sales activity, more investor participation, and more consistent deal flow. And when more investors are buying, it's simply easier to move contracts. There's more demand on the other side of the deal. That's why these markets show up so clearly in the data. It's not because wholesaling only works here, it's because active markets make it easier to do volume, stay consistent, and build momentum as a wholesaler. A rising market attracts more buyers, more capital, and more opportunity. So if you're deciding where to wholesale real estate in Texas, the smart move is to often start where activity is already strong, where investors are already buying, and where the deals are already happening. Now that we've covered the law, the contracts, and how wholesaling actually works in Texas, let's answer some of the most common questions people still tend to have. First off, is wholesaling real estate in Texas a good strategy for beginners? Absolutely, when it's done correctly. In fact, wholesaling can be one of the lowest risk ways to get started in real estate because you're using contracts, not capital. You're not taking on any long-term debt, and you're not holding property long-term at all. That said, the key is doing it legally and transparently. When beginners run into problems, it's almost always because they didn't understand disclosure requirements, they used bad contracts, or they relied on risky marketing tactics, which often put them in a financial hole. When you use a strategy like our MLS offer system, you can create hyper-profitable deals without spending much on overhead at all for your business. When wholesaling is structured properly, it can be an excellent entry point for new investors to get paid to learn. The next question, can I assign contracts in Texas? Hopefully you know by watching this video, the answer is yes. Texas contract law allows assignment unless the contract specifically prohibits it. Most standard Texas purchase agreements, including the commonly used TREC contracts, are assignable by default. As long as you're acting as a principal and you're assigning your own contractual interest and comply with disclosure requirements, assignments of contract are completely legal in Texas. Another question we get all the time, do I need a real estate license to wholesale in Texas? The answer is no, not if you're acting as a principal. As we covered earlier, the Texas Occupations Code requires a license only when someone is acting for another person in a brokerage capacity. When you wholesale correctly, you are a buyer under contract, selling your own contractual rights. TREC has explicitly stated that individuals engaged in wholesaling are not required to hold a real estate license as long as they disclose their interest and do not engage in brokerage activity. People also ask, can I use a real estate agent to help me wholesale properties in Texas? The answer is yes. In fact, working with real estate agents, especially when wholesaling properties off the MLS, can actually reduce risk, not increase it. Real estate agents help submit offers properly. They already have relationships with the property owners that we're looking to buy deals from. They also use standardized contracts and operate within a regulated framework. You just need to be clear about your role as a buyer and a wholesaler and make proper disclosures. Now, the next question is, what's the difference between marketing a contract and marketing a property? This is one of the most important distinctions to understand. Marketing a contract means you're offering to assign your contractual rights as a buyer. Marketing a property means you're offering the real estate itself for sale. The first is allowed for principals. The second can require a license. Clear language and proper disclosure make all the difference. And just to be safe, we advise our students to create relationships with cash buyers ahead of time so that you never actually have to market your contract for sale in the first place. You already have pre-existing relationships with end buyers that are waiting for your call to buy your next deal and pay you assignment fees. Now, the next question is, what laws should wholesalers be most aware of in Texas? At a high level, wholesalers in Texas should understand three main areas. The first is Texas contract law, which governs assignments of contract. Then there's Texas Property Code Section 50205, which governs disclosure of equitable interests. Then there's Texas Occupations Code Chapter 1101, which governs licensing and brokerage activity. If you really want to go deep and get ultra confident like I've done, go ahead and read these laws. You'll feel so much better and really know the landscape. If you understand those three areas, most confusion disappears. At this point, you should have a very clear answer to the question that brought you here. Is wholesaling real estate legal in Texas? Yes. Wholesaling real estate is legal in Texas when it's done correctly. And now you understand what correctly actually means. You've seen that wholesaling in Texas is grounded in Texas contract law, which allows assignment. Texas Property Code Section 50205, which is the equitable interest disclosure. Texas licensing law, which focuses on representation, not assignment. And clear guidance from the Texas Real Estate Commission, which acknowledges wholesaling as a lawful activity when done properly. This isn't opinion. This is law, regulation, and documented guidance. You've also seen why so much confusion exists online. Most of the fear-based clickbait content isn't about wholesaling at all. It's about marketing laws, cold calling restrictions, and text message compliance. Those laws regulate how people market and advertise, not whether wholesaling itself is legal. When you separate marketing from contracts, the picture becomes very clear. And that's exactly why we focus on wholesaling with the MLS offer system. Because when you eliminate direct-to-seller marketing and operate through listed properties, licensed agents, standard Texas contracts, and proper disclosures, you remove the biggest sources of legal and compliance risk entirely. Now, here's the most important takeaway. Wholesaling doesn't become legal because you want it to be. It becomes legal because you structure contracts correctly. You disclose what Texas law requires, and you act as a principal, not a broker. When you do those things, wholesaling fits squarely within Texas law. If you want to implement what we've talked about, not just understand it, I want to make this very easy for you. I personally paid over $1,700 to have a Texas real estate attorney draft the exact documents needed to wholesale legally in Texas. These include a Texas purchase agreement suitable for wholesaling, a custom Texas assignment contract, a seller disclosure that complies with Texas Property Code 50205, and a buyer disclosure for the end buyer. These are the same documents that we use when wholesaling in Texas, and I'm giving them to you completely for free. You can download them using the link below this video, or just go to realestateskills.com/Texas. If you want help implementing these strategies, especially using the MLS offer system to consistently acquire great deals right from the MLS, book a free call with one of my investment advisors. We'll show you exactly how our Pro Wholesaler VIP program can help you close deals consistently, legally, ethically, and with confidence. Just go to realestateskills.com to learn more, or just click the link in the description. If you take anything away from this video, let it be this. Wholesaling real estate in Texas is not about loopholes. It's not about tricks, and it's not about pushing the limits of the law. It's about understanding the law and operating within it confidently. If this video brought you clarity, that's exactly why we made it. Go ahead and like the video, subscribe for more legal and practical real estate breakdowns, and comment below with any remaining questions you have about wholesaling in Texas. Thanks for watching, and I'll see you in the next one.